Former special counsel Jack Smith ripping Jim Jordan, the MAGA Republican, to shreds after Jim Jordan, who currently chairs the House Judiciary Committee, referred Jack Smith to the Department of Justice for criminal prosecution. Jim Jordan contriving and lying that Jack Smith lied during his testimony before Congress. We all showed you Jack Smith's testimony, both the initial deposition, which the MAGAs wanted to not show publicly, and then they are like, all right, let's try again, because the whole goal was to try to...
Did you understand you lost a child?
FBI just raided Trump. We already know what's up. We knew that this day would come. Patriots are showing up. Yeah, the FBI just raided Trump. We already know what's up.
For homicide detectives, their chance of solving a murder is cut in half if they don't get a lead within the first 48 hours.
Mar-a-Lago, land of the free, where the minimum wage can't buy a cup of tea. Golden toilets, paper-thin walls, listen closely, you can hear the Mar-a-Lago.
Lay a perjury trap to then criminally prosecute Jack Smith. And, Jack Smith went in there knowing that quite literally every word he said, even if it was an I don't recall or an or an that Donald Trump and Jim Jordan and James Comer and these vile MAGA cultists would do everything possible to try to prosecute him by just trying to find any lie or anything. And so he was very careful. His testimony was very strong. He answered every question. He made it clear he would have answered more. But you'll recall that the MAGAs, working with Trump's DOJ, refused to allow him to testify about volume 2 of his investigation, the Mar-a-Lago document aspect of it, where Trump took the classified information. Although based on all of Donald Trump's war crimes and horrible behavior right now, that even just the notion of Donald Trump taking classified information, to Mar-a-Lago feels kind of tame compared to what he does any given day right now. And it's sad and sick that we've gotten here, but here we are. So Jack Smith is represented by Covington, one of the top firms in this country. They sent the following letter to Jim Jordan and Todd Blanche, just ripping Jim Jordan. It's succinct. It's a powerful letter. I want to share it with you because this is like just a perfect lawyer letter, aggressively dealing with these issues. He's represented by Lanny Brewer and Peter Koski. Let's take a look at what they wrote to Jim Jordan. Dear Chairman Jordan and Blanche, the House Judiciary's Committee referral to the Department of Justice of our client Jack Smith is based on a spurious claim that Smith provided false testimony during his 8-hour deposition on December 17, 2025. The referral is made not because Mr. Smith made a false statement. The letter concedes he did not, but because he did not proactively disclose information that was not responsive to a question asked. During his testimony, Mr. Smith provided truthful, responsive answers and candidly discussed his work as special counsel. This referral reflects a chilling eagerness to weaponize the justice system by attacking a career nonpartisan public servant who faithfully and fearlessly performed his duties by following the facts and the law. The purported predicate for this referral is based on the following exchanges. Question: did you seek a search warrant for the content of any text messages from members? Answer: from members? Question: yes. Answer: no, I don't recall that. Question: okay, it was just toll records? Answer: correct. Next set of questions. Question: did the toll records that you requested from the senators, did they include the content of the phone calls? Answer: no. Question: did the records that you requested, the toll records from the members of Congress, include the content of the text messages? Answer: no. Those answers Jack Smith's lawyers write in this letter, are unimpeachably truthful. The toll record subpoenas that were the focus of those questions did not call for the content of text messages. The questions and answers preceding and following these exchanges also make clear that the focus of the questions was on the toll record subpoena. Notably, the referral letter does not contest the truthfulness of Mr. Smith's answers. Perhaps in recognition of this deficiency, the referral letter instead relies on the unprecedented theory that Mr. Smith provided false testimony, not because of what he said, but because of what he did not say. Specifically, the referral argues that by not proactively disclosing that the special counsel's office collected from the National Archives records from the White House phones that included text messages between White House officials and Republicans and Democratic members of Congress, Mr. Smith violated 18 U.S.C. Section 1001, the federal false statement statute. The letter advances this theory, even though that information was not responsive to any question asked. This dangerous theory of criminal liability has no limiting principle and risks ensnaring every witness who testified before a congressional committee who does not proactively disclose information that is not responsive to questions asked. Mr. Smith approached the investigation into Trump as he approached every other investigation throughout his career, following the facts and the law while adhering to the Department of Justice protocols and regulations. He was transparent in disclosing that these text messages to Trump's personal counsel in discovery. If Trump's attorneys thought that Mr. Smith and his team had done something unlawful or improper in obtaining these text messages, they could have filed a motion to that effect. Notably, they did not. Mr. Smith agreed to testify before the House Judiciary Committee, fully cognizant of the risk that Trump's Justice Department would try to find something in his testimony to serve as the basis for a criminal charge. This risk existed not because Smith would make a false statement, but because Trump has repeatedly ordered that Mr. Smith be prosecuted and jailed. That is not the rule of law, and it contravenes the principles that are critical to the vitality of our democracy. An honest assessment of the facts and the law compels a rejection of the meritless referral signed by his lawyers at the Covington Law Firm. Let's bring in Harry Litman from the Talking Feds YouTube channel, Substack, and podcast. Harry, I wanted to read the full letter, 90% of it, so people can understand what was being laid out there, how ridiculous this referral is, and that now the DOJ is not even referring people out for what you say or what you do, but hypothetically what they want you to do. It's now thought crimes that they are going to prosecute Donald Trump's political enemies for. It reminds me of that movie with Tom Cruise in the future where they start prosecuting people for things that aren't even done yet. And this is a dystopian modern day version of that. And hat tip to Covington for also staying in the fight when so many firms bent the knee. Harry, what do you make of it?
Wow. So, look, Covington did a smart thing by just starting with the words. If you listen to, spurious argument, thus and so, that sounds like what lawyers always say. But this case is a dog equaled only by the James Comey prosecution for the seashells of 8647. No self-respecting prosecutor would even give a moment's thought. I just want to say it again. Did you seek a search warrant for the content of any text messages from members? And so I think the Midas Mighty knows this, and Talking Fed heads as well. But there are two very different things that prosecutors can seek. A very common thing that doesn't require much of a showing, and the Supreme Court has said no expectation of privacy, is just a little readout that says, here's the number they called, here's how long the call lasted. That's really what you use it for. And as Smith actually explained in another part of his testimony, this would have been the stuff that you could say, what was going on January 6th? Okay, 2:15. Perry calls Meadows, 2:22. Meadows calls Trump. I mean, it's not only not sinister to do it, it's essential. Remember, all this stuff was going on the Hill, and we don't even know about this yet. but you have now a refrain of senators and members of Congress saying, you spied on the content of my emails and texts. And the simplest thing to say is, no, not at all. The law makes a distinction. Here is just the little metadata, as it's called. And then here's the text. And you can get that, but with a much higher level of proof and subpoena, et cetera. That's a serious expectation of privacy issue. So when they ask, did the search warrant, it's a search warrant, they're asking a specific one. Did you seek a search warrant, which would be what you would do for the content of any text message from members? No, I don't recall that. Just toll records. Correct. And then you go on. Did the toll records that you requested, did they include the content of the phone calls? I think this is actually friendly questioning, making clear that the senators
You have reached the desk of Superintendent Sherwin Ferguson. Please leave your contact information and the purpose of your call, and I will contact you as soon as possible. Thank you.
Record your message at the tone. When you are finished, hang up or press pound for more options.
Hey, Commander Ferguson, this is Amy Donaldson again. Today, it's 465 days since Seth fell out of a solid glass window at the Saratoga Loft Apartments, 212 Loyola. And the NOPD has failed to do anything other than blame the victim and torture the family. I'm in New Orleans. You've received a few phone calls from me and never responded. I think it's time you do. I would like to meet. Thank you. 828-329-4855.
Corner. Absolutely. We actually do the same thing, so just make sure we have the gist of the meeting squared away.
At the bottom of the grave, you're digging out. When the truth comes out, yeah, you know this is just the beginning. Lights crumble down when the truth comes out. Lights crumble down when the truth comes out. You can try to cover up the lies, but I know the truth.